Welcome to Tax Sale Insiders, the latest from Tax Sale Resources, bringing you information about tax sales from experts in the industry. We interviewed Deborah Feldstein of Pellegrino and Feldstein, based in Denville, New Jersey. Deb and her partner Michael Pellegrino were pioneers in the tax lien world almost 24 years ago and have written a book called Tax Liens, the complete guide to investing in tax liens in New Jersey. Deb and Michael specialize in tax lien foreclosures in the state of New Jersey, so Deb's knowledge is vast. So sit back and relax for another episode of Tax Sale Insiders, powered by Tax Sale Resources.
All right, welcome everybody to this episode of Tax Insiders. I'm Brian Seidensticker, CEO of Tax Sale Resources, and with me today I have Deb Feldstein. She's with Pellegrino and Feldstein Law Office in New Jersey, which are by far the premier experts of tax liens in New Jersey. And Deb's partner, Michael, actually literally, I'd say, wrote the book on tax liens in New Jersey many years ago. And I don't have the book with me, but I did print out, anybody can see that. It's a nice green book, very informational. If you are intrigued by New Jersey tax liens after today, I definitely recommend getting that book and reading in more detail. But anyway, Deb, thank you for joining us.
Well, thank you so much, Brian, for having me this morning. It's great to be here.
It's kind of a crazy world. We're doing this via Zoom, which has become normal in today's world.
That's right.
We were just chatting about COVID in general, and I guess before I get into COVID's impact on liens in New Jersey, I guess give me a little background on yourself, Deb. How'd you fall into the industry? I call it falling in because most boys and girls don't grow up with aspirations of becoming an attorney or an investor in tax liens. So how'd you get into this sect of the real estate industry?
Well, I had started off working in New York doing bankruptcy work, and very quickly wore myself out with the commute from Jersey going into the city every day. And I sort of just by chance met up with my partner, Mike Pellegrino, and he at the time was only doing tax lien foreclosures. And in truth, I knew nothing about them. He actually just got started on it himself because a family member was a big investor in tax liens in New Jersey. So that's how he got started in it. And when I joined him, which was really within a year of him getting started on his own practice, that was all he was doing, was doing tax lien foreclosures at that time. And we've been doing this together now for 23 years. So that's all we do. Everything we do is in connection with tax lien foreclosures. We do the foreclosure work. If a bankruptcy is filed, we handle the bankruptcy for the client. And if the client is successful and obtains title to the property, we'll handle the real estate sale when they go to sell the property down the line. So everything we do is just in connection with tax liens. We don't do anything else.
Well, I'd say that would make you absolute experts. If you have enough business in this one piece of law, then I can't imagine having any more perfect partner. Is probably a better way to put it, in the process in New Jersey. And I know we'll get into it, but Jersey's got all sorts of complicated nuances to the law there, which makes it imperative to have a partner, an attorney that is very familiar with the process, to make sure you don't end up with I call worthless paper at the end of the day. So I'm going to start with the basics, Deb. Probably very simple for you. Some people that are coming from other states don't have quite as good a handle on it, obviously, as you do. But would you consider New Jersey to be a lien state or a deed state?
New Jersey would be considered a lien state, Brian. When a lien holder obtains the tax sale certificate, they have absolutely no ownership right to the property whatsoever. They merely have the lien on the property. And with that lien gives them the right, obviously, to foreclose and gives them the opportunity to own the property down the line should the lien not be redeemed.
Got it. Okay. And then how are auctions conducted? Are they, most times by the county, or are they by the city? Are they live online? Help me understand that.
Well, historically, we've always been by municipality, and each municipality within the state, and there's 566 municipalities, would hold their own auction, and it would just depend on whether they followed the calendar of fiscal year. So they would either be doing their auctions in June or December, and you would just have to check to see when they would be holding them. And the tax collector would be publishing in the newspaper and then posting that notice in 5 locations within the municipality. However, we always had them in person. And I used to always tell my clients that you should, before you even begin investing, I would always recommend going to an auction just to see how it's run, because they're pretty amazing things to go to if you've never been to one.
Wild ride.
But now with COVID, the municipalities have, first of all, delayed sales that would have been in June.
Mm-hmm.
And for most part, it's because they're moving to online, right? Because we can't have in-person sales right now because of the pandemic. And so we're seeing more and more of the municipalities moving to this online auction process,
Mm-hmm.
which I know throughout the country, many other states do.
Mm-hmm.
New Jersey just never did that before. So it's always been in person. We're now moving to online. And I really believe that with the pandemic, I think will probably remain online, because I think the tax collectors are going to see that it's actually probably easier for them to manage the sales online versus in person. I think we were slow to do that because we have a lot of tax collectors and we have a lot that have been doing this for a long time
Mm-hmm.
and are probably not comfortable with the idea of doing things online, but now they don't have a choice. So I think that I would be very surprised if we don't just move to online going forward.
Got it. So not just a temporary solution. You think it'll be a permanent staple?
I think so. I think it's going to be easier for the tax offices to manage. Remember, I mean, we have so many municipalities. I think for even the potential buyer of a lien, it's going to be so much easier, because you used to have to physically go and you'd have to pick which municipalities you were going to bid at, because you couldn't be at more than one at a time.
Yeah.
And they're only split by June and December. So you were really limited.
Right.
In where you could go.
Got it. Now, it's, to my knowledge, New Jersey's always been pretty competitive, and it has a unique bidding method. And I don't want to steal your thunder, Deb, but it's not just a bid down, but then people can actually bid the interest down to zero, and then you start bidding premium on top of that. Is that right?
Absolutely. So in New Jersey, our process is obviously the taxes are whatever they're due. Can't bid on the taxes, bid on the interest rate. And we start off at the highest rate of interest in New Jersey is 18%.
Mm-hmm.
If you and I were both bidding on the same property and I was starting, I would bid at the tax amount due at 18 and you would go to 17. And if we both wanted it, we'd keep going down until we hit 0. And if we both were still interested in the property, whoever was next would stay $100 premium. And you go up by $100 increments until somebody finally bails on purchasing and you have one successful purchaser. Now the premium is held by the municipality for 5 years. So that tells the lien holder that they have to make sure that they've initiated the foreclosure early enough to trigger a redemption if a redemption is going to occur. Because if you wait and the 5 years passes, that money goes to the municipality and the lien holder can't get a refund even if the lien is redeemed. So it's very important for the lien holder to make sure. I have clients that call all the time and they've held the certificate for 4 years. And I look at the certificate and I see there's a $50,000 premium and I tell them, we have to get this done in a year. And depending on the court, we may not be able to. It's really tight. So lien holders really have to pay attention to that and not hold on to it. After 2 years, you have the right to institute the foreclosure. You should get started if you have a premium on your lien.
Got it. So it's not that you don't have to start it within that 5 years. You have to be done, right?
You have to be done.
And that whole process, I know, can vary from one lien to the next. And so
Absolutely.
we don't want to wait till last second to start that.
Yeah, I mean, people should bear in mind, a lot of the times clients don't realize if the property owner has a common name, like Jim Johnson or Jim Smith, we're required to join all judgments that come up against that person that we can't eliminate. And a lot of times you can't eliminate them. And with someone with a common name, you could wind up with 100 judgments that you have to attach to your complaint, which will delay the foreclosure, because you have to, show that you've done due diligence in trying to locate all of these defendants.
Oh,
so
wow.
It's really important. That's why I say when you have a premium, the sooner you start, the better.
Got it. I'm a little ahead of myself, but since we talked about that 5-year deadline on the premium, is there technically an expiration to liens in New Jersey, or is it a high incentive to just get it done within that 5 years because you're going to be losing out on that premium?
Certificates are valid for 20 years, but let's just say, and I've had a couple of clients who've actually held certificates for that long and didn't institute a foreclosure for whatever reason. You can still foreclose. You have to get like a certification from the tax office. There's certain steps that you have to take to be permitted to complete the foreclosure. But as long as your certificate's still valid and you have proof that you've been paying subsequent taxes, the court will normally allow you to foreclose. But you should really do it within, 20 years is a long time. So if you didn't have a premium, but you'd be surprised. We've done it a couple of times for some clients that have just held on to them for a long time for whatever reason.
So there may be the unique instance where it makes sense to hold it. Definitely needs to be an instance where there's no premium.
Correct.
But properties can change in value enormously, right, in 20 years. So, and usually in tax liens, it's not for the better. Usually it's getting worse over time. So it's
correct.
Not the norm, and maybe not recommended in most cases, it sounds like.
Yeah.
Okay. So I'm gonna step back a little bit into, the interest at 18 that gets bid down to zero, and then there's a premium. So if it's down to zero and there's a premium, how does anybody ever make anything on it? How does the interest work?
Okay, well, if you've bought the initial lien with a premium, obviously there's no interest. The way the investor would then make money is by paying the subsequent taxes. Okay, so if you pay the subs, and that's what we call them, the subsequent taxes, when they become due, they attach to the lien automatically at 18% interest.
Okay.
So that's how you're going to really make your money on a redemption, right? So I always tell my clients, there's really two ways to pay your subs. And you can, I have a preference, but really it just depends on what you want to do. I always tell my client, if you pay the subs as they come due, which is quarterly in New Jersey, right? So we have to pay our taxes quarterly here, that as long as you're paying them quarterly, and you have your affidavit, you have to show that you have an affidavit of subsequent tax payment with the tax office, so it attaches to your lien at 18%. You're going to immediately start accruing interest on that subsequent tax payment. So you're starting to make your money right away, right?
Okay.
So to me, I think that's the better way to do it. You keep track of what you're paying, you're accruing interest right away, and you don't have to worry about the second method. And the second method of paying subs is allowing it to go back to auction. The reason why I don't like that is because, one, like I said, historically, you'd actually have to go to the auction. Why would you want to have to really do that? Now, it's online, so maybe it will be a little bit easier for a client to choose going that route. And the benefit to going that route is the 246% penalty that attaches to the liens when there's an original sale, right? So for any lien that's sold for more than $200, you get a 2% penalty that's added on. For anything that's $5,000 or more, it's 4%. And then it's over $10,000, it's 6%. And some of my clients would prefer to get that penalty added to a new lien rather than pay the subs as they become due.
Is that based off of when the redemption is going to happen? As in, because 18%, right, is 1.5 a month, or is that over? Is it daily over?
It's daily. It accrues daily.
Okay.
So some of my clients, like I said, prefer to just, it's really, I think it's a business model that you have to look at. Again, my recommendation is always pay as they become due. That's in my thought process. But we have a lot of clients that like the other model and would rather pay and get that 2, 4, 6% penalty added to a new lien. Okay. Now, back in the day when you had to go in person, there is always a chance that someone's going to outbid you, in theory, right? Because you're bidding on a new lien. The standard format would be if you hold a prior lien, when the bidding starts, you just yell out prior. And that would let everybody in the room know that you hold the prior lien. And normally if that occurs, everybody is being put on notice that if you outbid me, because when I'm holding all I'm going to do is go to the tax window at the end of the day and pay it off, and it's going to become a sub on my lien. So I'm letting you know that I hold the prior, so I have the right to go pay you off. You shouldn't really bother bidding against me. And most people who are sophisticated and know what that means won't bid against them, because they're like, oh, they hold the prior lien, they're just going to go and redeem me as soon as this is over. But there's still a chance. You can't be sure, so I always say you have to take the time to go to the auction, and there is that slim chance that someone else will outbid you, and then you have to go through the process of paying it off anyway, and it becomes a sub and attaches to your lien anyway.
Now, if you go through that process and you pay it off and attach it to the sub, does it still earn 18%?
Yes.
Okay. Yes. Interesting. So I'm sure there's more instances, and like you said, every model is a little different, but where it may make sense to go and get that penalty is the instance where maybe it's not bid down to 0 with a premium. Maybe people are getting it at 15. Okay, go to the next year if you can get it at 15 or so, but you're also getting that, I'll say, kicker, right? On top of that.
So you're getting the 18% plus the kicker. And that's why some of my clients would, they have to do a calculation. Is the interest accruing daily going to be more significant? At least to me, that's what I tell them. Is that a better return, or is getting the penalty? And again, I also tell them it has to do also with the convenience factor of having, back in the day, having to actually go to the auction and you could have to be at multiple auctions depending on how many liens you have in different, municipalities. So it can become a little tricky to coordinate all that. And I just think, in my mind, it's easier to just make sure you're paying as you go. So when new clients come to me, I say, I think that's the easier way. Yeah. But I always tell them you should look into it to see if for some reason the rate of return is going to be better for you doing it by going to the auctions. But again,
so maybe start out with a simplistic approach. I guess we can't really recommend what people do, but keep it simple to start with, and then you can always add to complexity if it increases your return marginally.
Right. Absolutely.
So that kicker though also applies to the primary lien, the first one you buy, right?
Absolutely. Okay. The original lien, when you purchase it, again, you'll be entitled to a 2 or 4 or 6% penalty, depending on the amount that you paid at the time, not including premium, but the amount of taxes that were paid.
Okay. So and it's just on the taxes, not the premium.
Correct.
So the premium is going to be held by the county and earns nothing. It's kind of,
correct.
Lack of a better word, dead money, right?
That's right.
With a deadline that you definitely want to hit in order to get that back.
Yes.
Got it. Interesting. Okay. So help me understand. So I went to the auction. I bought that lien. I guess it doesn't really matter if I bid it down to 0 and I bid a premium to it. And now I'm the proud owner of that lien. Other than paying the subs or attending those subsequent sales to add to that balance, are there any other steps that I have to take as a lien holder from a notice or a filing or anything like that?
You have to just make sure that the tax sale certificate gets recorded in the county.
Okay.
So once you get your lien, you just have to make sure you record it. And that's basically putting the world on notice that you're a lien holder on the property, right? So that's what you need to do.
So they just give you a piece of paper. You have to go record it.
You have to go and record it. Absolutely.
Okay.
So, you have to make sure that you do that.
Is there a
Now,
time
you off the top of my head, I believe there is. I would have to check though, but I believe you
Okay.
do have a time limit to record it.
Okay.
But I can check on that for you.
Interesting.
And then you don't have any other notice requirements until you decide to initiate your foreclosure, right? So once
Down
you,
the road. Okay.
yes,
Okay.
and at that point, your notice requirements will kick in.
Okay. I'm going to come back to the foreclosure process. I forgot to ask you a little bit about that prior lien notice that folks used to yell out at the live auctions, right? With auctions going online, I'm assuming the auction houses don't allow you to really do that, right? So you lose that knowledge. Is that accurate?
I think because you're sort of signing up, it's a different process. So you're signing up on the website. I think, and I'm not sure because I've actually I haven't been able to participate in one or because I can't just be a fly on the wall.
Right.
I would think as a prior lien holder, it's going to notice that you're there because you're signing up. And I have a feeling that it's going to note that there's a prior lien holder for the property that's at the auction, so that the other bidders are going to be made aware of that fact for each property if there's a prior lien holder participating.
Okay. So I guess for the folks interested in going to the auction, is definitely something to check out as you register.
Yes.
It's just like you would highly suggest is going to an auction first before you ever place a dime, right? Still do that, even though it's online. Attend, register and attend just to watch to see how it.
Just to see how it works.
Got it. Okay. All right. So sorry for scrolling there a little bit. Now back to the foreclosure. So after. Is it 2 years and 1 day? Is it 24 months? Is there anything specific about on this day you can start that process?
So you're allowed to initiate your foreclosure 2 years from the date of the sale.
Okay.
So whatever the sale date was, you have 2 years from the date of the sale that you have to hold the certificate. And what we recommend is 30 days or so before the 2-year period is extinguished, we file what's called a notice of intent to foreclose. And what that does is we mail that notice to the property owner and anybody else within the chain of title that would have the right to redeem, such as a mortgage holder or a prior tax sale certificate holder. So they're being notified that we're intending to file a foreclosure action.
Mm-hmm.
And if they wish to avoid incurring legal fees and costs associated with that foreclosure, they have approximately 30 days to go to the tax office and pay off the tax lien, right? So that's the notice of intent. We're letting them know our intention is to foreclose, and if they want to avoid incurring additional fees and costs, they should go and pay off the lien now before we get started, because once we file the complaint, then the lien holder is entitled to recoverable fees under the rules and statutes in the state of New Jersey.
And those are, you mentioned for the other lien holders, it's recoverable from, like they will incur those fees, some fees if they don't?
What happens is the redeeming party, once the foreclosure complaint has been filed, when the redeeming party goes to the tax office, the tax collector will contact us and get an affidavit of fees and costs.
Okay.
So there's statutes and rules that set what our client would be entitled to recover from a redemption.
Right.
You can't get all of your legal fees and costs back because it's set by the statute, but
Right.
you can get a portion of it back, and they're entitled to do that once the complaint's been filed.
Okay, so that's only upon redemption. I guess a mortgage holder can choose to do nothing. It doesn't cost them anything, but they're obviously going to lose their position on that property.
Correct.
Okay, so it's for those intending to redeem, get this done in 30 days, you're going to have additional fees on top of that. Okay.
Correct.
Now, is it those legal fees that can be added? Do they earn any interest, or is that just a redemption?
No, it's just straight fees and costs.
Okay, and then the interest being earned on that lien, does that change after you file that intent at all?
No.
Okay, so it stays.
Whatever you bid, if you were the successful bidder at 18% continues to accrue throughout the foreclosure.
Okay.
Up and until the redemption.
Okay, and then the subs, if you have subs, continue to earn 18.
Absolutely, and they attach to the lien, so that would all have to be paid off at the redemption.
Okay, got it. And sorry, I'm going to scroll a little bit again because I'm thinking of scenarios, right? Um, I bought a lien in 2013, right, a long time ago.
Okay.
I chose not to buy those subs. Well, actually, that's probably unrealistic. I bought a lien in 2020? I bought a lien in 2018, right?
Okay.
Somebody else comes and buys that lien in 2019. I chose not to go buy that sub, even though financially it made sense. I have the right to then go redeem that sub, get my 18%, and then also pay any other subs that have been paid and start earning 18% anytime. So the oldest lien has priority, and it doesn't go in reverse. That's that prior lien in 2018 can't go back and pay mine, but I can pay theirs.
Correct.
Okay.
So the way it works in New Jersey, just to reiterate,
Yeah.
the older lien can redeem the newer lien.
Okay.
The newer lien has to foreclose out the older lien.
Okay.
Right? So the oldest lien basically has priority. They can go and they have the right to do the redemption. The newer lien has the right to foreclose.
Got it. Okay. So certainly when you're doing your research on which liens you want to buy, it certainly is highly recommended to see which ones have prior liens or not, right? Because that'll tell you
Yes.
whether you're so I guess that would take place of the notice you typically got at the auction of prior, right, if they attended.
Right.
And you would at least have that knowledge going into the auction. Got it. All right. So sorry, back to foreclosure. I filed my notice of intent. I waited my 30 days. Then what?
If no one's redeemed, then we would file the actual foreclosure complaint, and that complaint will recite with specificity the information that's on the tax sale certificate, and it will also recite with specificity any other lien holder or judgment creditor that showed up within the chain of title, because all of those lien holders and judgment creditors are going to be named as defendants in the foreclosure action.
Okay.
So once we've done that and we filed the complaint, then we have the difficult task often of serving notice of that complaint to all the defendants. And that's the costliest and longest process within the foreclosure, right? Because we have to show the court that we've done our due diligence and we've exhausted every possible means to notify all of the defendants in the foreclosure in order for the court to allow us to proceed with the action.
Okay.
So, yeah. So a lot of clients get frustrated when they see that we've been trying to locate defendants for 6 months or 8 months. But the truth of the matter is, every time we send out a process server to an address based on the mortgage or the prior certificate or the information provided in the judgment, if the process server comes back and gives us another possible address, we're required to try that address as well. And then we also have to send, a letter to the post office asking them to check their records to see if this is the last known address for this person or if they have another address. And if the post office provides us with more information, we're required to continue to attempt service until there's no other address that we can try. And once we've exhausted all of those attempted addresses, if they're all unsuccessful, then we have to publish on the file. And that's a publication that's done within the municipality, but it's really within the county. So you have to make sure that the newspaper you're using is a newspaper that's published regularly within the county where the municipality is located. Got
it. Okay. So that you have to continually try to contact that interested party through whatever means that one is required, and then also what's available, I'm sure, as you get more information as you go. So I'm sure all of that process, right? If you're having to notify more and more people, there's more and more fees. Does that just get stacked on top of the redemption and that all gets reimbursed? Well, the good thing about the process servers, at least the one that we use in New Jersey, and I'm sure this is we don't use the sheriff. So the process server only charges for a successful service. Okay. So even if they go out 10 times to 10 different addresses to find a defendant, they only charge you when they get the service, which does help
in terms of those service costs, because service costs are, like I said, it's the most expensive area, because you have to do your mailings for regular and certified mail, and you have to, it's a costly area. There's a limit in the statute per the number of defendants. You're entitled to a certain amount of recoverable fees. The court looks at how many defendants are included, and they just, they make the determination based on the number of defendants. So
Okay.
Again, if you have a very large file, you will get more money back if there's a large number of defendants that you're serving.
Okay.
In comparison to a smaller file. Absolutely.
Got it. Okay. So I've started the foreclosure. I have completed all of my notices, or serving them, right? Essentially what you're doing. What then?
Okay, so once we've completed service or exhausted all of the possible attempts at service, and we've published on those defendants that we haven't located, we move to what's called default and order setting time. So we notify the court that we've noticed the defendants properly, so they can be defaulted because they haven't filed any kind of responsive pleading or answered in the action. And then we request from the court that they enter an order setting time, place, and amount of redemption. And that order lets the defendants know that they have a date set by the court, and it's 60 days from the date the order's been entered, by which they can go back to the tax office and pay off the lien. And at that point, if those 60 days have expired and they have not gone to redeem the lien, the court allows us to proceed with the foreclosure. At that point, we have to get what's called an affidavit of non-redemption from the tax collector, and the tax collector is merely certifying that nobody came to redeem the lien within the time period that the order had set.
Mm-hmm.
And with that affidavit, we're allowed to then apply for the final judgment. And in New Jersey, your final judgment is actually your deed to the property. So once we've obtained that final judgment for the client, they now are the owner of the property.
Okay. Got it. So there's several steps you got to take along the way, not, from that 2-year period all the way to obtaining ownership. I know it varies by case, right? Depending on how many people you got to notice, and do they fight it? Is there a bankruptcy? All that great stuff will vary the time greatly, but is there a rough average of the time period it typically takes from end of that 2-year period till you are awarded ownership?
We typically tell clients that it normally takes about a year from the date we started the foreclosure to get it completed.
Okay.
There are some that can be completed as quickly as in 6 to 8 months, and there are some that can take 18 to 24 months. It just really depends on the complexity of the file and the number of defendants, but the normal length is about 12 months, so it's normally about a year.
Okay. So from the time, if you're pursuing this investment with the intent of owning property, you got to keep in mind it's a minimum of roughly 3 years from the time you attend that sale till you might end up with a deed. Okay, so they awarded your ownership. I know some states have little nuances of, like, they give you a deed, but you have to record it in 30 days or anything. Is there anything quirky like that?
No, we tell our clients to record it immediately, and
Mm-hmm.
we usually do that for them. And we also recommend, obviously, that they go ahead and try to get a title insurance policy as soon as possible thereafter. But obviously, recording the final judgment is important, and you should do it as quickly as possible, because that lets everybody know that you're the new owner of the property. So for
Okay.
purposes of notification, you want people to know that you're now the owner of the property.
Got it. So it's not required by a statute to do it within a certain time period, but
No.
it's highly recommended.
Yes.
Got it. Okay, so you mentioned title insurance. So I've got this deed, right? I have ownership. Is the title insurable at that point, or is there an additional step I have to go through, like a quiet title action or anything like that, to get insurable title?
There's no additional step that is required in New Jersey in terms of the foreclosure. Their final judgment, again, is the deed to the property, and you're the owner. However, I will tell you that title companies in New Jersey have become more and more reluctant to insure tax lien foreclosures immediately.
Okay.
And that's because there's what we call a 3-month provision and a 1-year rule that impacts your foreclosure. So we have a title company that's more aggressive in insuring, only because that's all they base. They're very familiar with tax liens, and they insure them regularly. So we can, on a case-by-case basis, get title insurance for clients within 3 months after the final judgment,
Okay.
which is considered great now in New Jersey because for the most part, they won't insure them for a year. But that's because there's a rule, 4:50, that will allow a final judgment to be reopened.
Mm-hmm.
And then there's a statute, which is what we call the 3 month or the 90 days, which allows a final judgment to be reopened within the 90-day period for different reasons.
Okay.
And so title companies have gotten skittish over the years about insuring after the 90-day provision. But again, there are some that will do it. The more aggressive insurers will.
Okay.
And you just have to hope that when the foreclosure was completed, that you can show that the owner and anybody who, like the mortgage holder, had personal service, because that's usually the kicker for the title companies. They want to make sure that you can show personal service rather than that publication I was talking about for defendants that you can't locate, because that makes them hesitant, and they think that there's a chance that someone could come out of the woodwork and say, wait, I didn't get notice, and I want to be able to redeem the lien if they have standing to do so. So that's a consideration.
So that first 90 days is there's a little more opportunity for somebody to come out of the woodwork, and then there is a provision for a year, but it's a lot less likely. So I'm assuming companies that you have relationship with, I mean, they're willing to do that because you guys did the work, right? And they're comfortable with you guys doing the work, and that's the only reason that they'll insure it or take that risk in that time period. So even though that title company will do it for you, you can't just take a random case to them and say, hey, insure this. The case would have to be done by you guys, correct?
They're very particular. They want to know that it's a foreclosure, firm that's handling, some other attorneys will try to do them and they're not as familiar with the process, and it is fairly intricate and nuanced. And if you don't have that much experience, they're more hesitant, I think, to insure.
Got it. Okay. Now, as far as how clear that title is, are there any other liens that survive that foreclosure process? And what I'm pointing to are code violations, IRS liens, maybe HOA liens that do survive tax lien foreclosure in other states. Is anything like that in New Jersey?
Well, one thing you should know, that in New Jersey, we're required to foreclose on any recorded liens or judgments, right? So code violations are normally not necessarily in New Jersey always recorded. You'll find them on a tax search or assessment. Like all of a sudden you'll see at the bottom that there's a cleanup fee or a vacant lot charge, and those weren't recorded in the county clerk's office. So if something isn't recorded, obviously we don't have the requirement of noticing them in the foreclosure, right? Mm-hmm. So that's something that you wouldn't have to include in the foreclosure. It's considered outside of a foreclosure, because again, the requirement is they have to record the lien or the judgment, whatever they have. And if they don't, and a lot of times in New Jersey, the municipalities don't.
Okay.
So they're like
not
part of the foreclosure.
And that didn't mow your lawn lien, code violations, sticks with it. Is it still due after the fact? So it's the proud new owner of the property, but you also have a fine due to the municipality as well.
A lot of times when I'm doing real estate closings for my client, and all of a sudden these fines just show up, we didn't know anything about them. Yeah. We usually have to do some negotiations with the municipalities to either remove them entirely. Okay. And some municipalities will, when they see that, they understand that if we did a foreclosure and we just took title, that we're selling it to someone, and that's going to benefit the municipality, right? You're going to sell it to someone who's either going to be rehabbing the property or moving into the property, and it benefits them. So when you make that argument, a lot of times they'll either significantly reduce the lien amount, or they'll just remove the lien amount entirely.
Got it. Okay. So they do stick with the property, but it sounds like most municipalities will work with you. Like you said, they want it to be back on the tax roll. And so if it means understanding that you didn't own this property when when these fines got slapped on it, we're not going to hold you accountable. They're pretty reasonable in that respect, it sounds like.
Yeah.
Got it.
Now, with regard to IRS liens, If there's an IRS lien on the property, we have to include that in the foreclosure. And that foreclosure does not go through to final judgment. So the process that I just described to you before does not apply when there's an IRS lien.
Okay.
When there's an IRS lien, we actually have to take the file to sheriff's sale.
Okay.
And by doing that, obviously a client is at risk that a third party bidder is going to come in and take title to the property. However, if our client is successful, the IRS lien is extinguished at the sheriff's sale. So that's the way you remove that lien from the property, is by going to sheriff's sale.
Okay. So it goes to a sheriff's sale, if where anybody can show up, right, and bid at that sheriff's sale.
Absolutely.
And they're bidding for the actual property at that point. It's a tax deed auction. Now, if it is the opening bid basically the total amount of the redemption plus
redemption amount? Yep.
Okay. So if somebody else happens to buy the property, at least you get all of your fees.
You get, yes, they'll get all their fees and costs, and they'll get their redemption. But for most of my clients, they want the property.
Right.
So what they do a lot of times is they'll take a look at the IRS lien. If the IRS lien is not significant in the amount, and or if it's almost close to being expiring, you know how they last for like 10 years and they expire, they'll choose to have us dismiss out the federal lien and go through the standard process of default, order setting time, and final judgment, and choose at closing to deal with the IRS lien at that time if it hasn't expired.
Got it. Okay.
That's a business decision, because if they really want the property and they're worried that at sheriff's sale they're not going to be the successful bidder, some of them will opt to go the route I just described.
Okay. So that's a decision to be made depending on how old the IRS lien is, the amount, and how bad do you want the property. Got it. Interesting. Okay. Well, I guess two questions. I'm going to go back to the liens after the sale. I'm switching topics slightly here, Deb. If a lien goes to sale, it doesn't sell, what happens to that lien? Does it just go to the next sale the next year? Can you buy that lien directly on assignment from the county, or what happens to those?
Sure. When a lien is not sold at the auction, it's struck off, and it's technically sold to the municipality at 18% interest. They're also called orphan liens when nobody buys them. So the municipality then holds the lien at 18% interest. Municipalities don't want to hold tax liens, right? The whole purpose behind the policy with regard to tax liens is so that they can get the money that they need to provide the services that people need within the municipality. So if they're holding a tax sale certificate, they didn't get any money for that lien, and that's money that that they still need. So they don't really want to hold them. You can take an assignment of municipally held liens. One of the benefits of taking an assignment of a municipally held lien is that it's automatically at 18% interest. So you're automatically getting that 18% interest that you would have had to bid at auction that you probably wouldn't have gotten. My caveat to that is, though, well, why didn't anybody want to buy the lien?
Right.
So
reason, right?
Right. There's usually a reason. And I tell clients who are very excited about taking assignments from the municipality, I always say to them, did you drive by the property? Did you take a good look at the property? Did you perhaps go to the municipal office and see if they could tell you anything about the property itself? Because people from the area, if they didn't bid on the lien, there might be a valid reason why. So that's always like the buyer beware type thing that I always say. You should really make sure that when you're taking the assignment, you really want the property, right? Because you could get stuck with something that you actually didn't want.
Got it. So you can buy these over the counter from the county if they don't sell, but it's like most over the counter liens in many states. It's they're there for a reason. Definitely do your due diligence before you place any dollars on it. Don't get excited because the Google photo says there's a beautiful looking house there. Got it. Okay. All right. So back to the process overall, it's fairly complicated, especially starting after that 2-year period. Where do clients or your clients typically engage you guys, Deb? Is it at that 2-year mark? Is it before that 2-year mark? When do you guys get involved?
We get calls at various times. We'll get calls from people who are looking to get started in what we call the tax lien industry and want advice, and want us to sort of walk them through the entire process from auction to final judgment, and even going through what happens post final judgment in terms of selling the property that's been that was the subject of a foreclosure. But for the most part, most of our clients start to get in touch with us right towards that 2-year mark from the date after they bought the certificate, looking to see how quickly we can get started and what the process is for the foreclosure.
Okay.
And that's usually when we see most of our clients.
Okay. So that typically clients will take that lien and go record it themselves, right? That's the biggest thing they need to do themselves, and then they can obviously buy the subs themselves or attend sales, for that 2-year period, and then they typically engage you toward the end of that redemption period, and starts to look like it might be a foreclosure.
Yeah.
Got it. Okay. All right. There's kind of 2 other questions, totally unrelated to the process, but I love asking folks that are as knowledgeable about how the state works like you are, Deb. One is there's several states that are changing significantly in their process. Is New Jersey anything like that, or any major changes to the process coming down the pipeline other than sales going from live to online? Any statutes changing, anything like that?
Yeah, we don't really see anything changing in the near future. The only thing, again, as you just pointed out, that's changed is the fact that they seem to be moving towards sales being conducted online versus in person, which for this state is a big change. But other than that, statutorily, we haven't seen any signs that anything's going to be changing within the foreclosure process that people would need to be aware of at this time.
Okay, so it's fairly stable, relatively.
Yeah.
And then what would you say is the biggest, maybe 1 or 2 biggest pitfalls investors fall into because they didn't do things right, that you would suggest that they do that are simple and would easily avoid giant pitfalls?
Well, I can talk about a couple of different things. Some that they should do so they avoid a pitfall, but there are some things that can happen that's what I call unavoidable.
Mm-hmm.
But really, a lot of times I find that people are bidding on properties that they think are valuable and really aren't. So we call this when they get to the end of the road and I get them the final judgment and I'm happy, right? I completed the foreclosure, you own the property. And then they turn around and tell me that they spent $100,000 on a lien on a property that's only worth about $40,000. And I say to them, well, didn't you do your due diligence? That's not something that we as the attorney would know. We have no idea what's there at the property. We don't go to the site. We don't know. We only know what's in the title search. So that's the only information that we have. So a lot of times clients just don't even know. I call it buyer beware. They don't even know what they've bought. They're so excited. They got their first lien at an auction, but they're not really, they don't really understand what they bought. And a lot of our clients are, in construction, contractors. So they're looking to and then they find out that the property is wetlands and you can't build on wetlands. So you have to really make sure you know what you're buying. I always say you have to make sure you know what you're buying. I've had clients that bought liens not on properties, but certain cities were actually selling liens not for the property, but there was a billboard on the property and the lien was actually on the billboard. And so I did a foreclosure and they found out that they owned a billboard. And there's no way to know from the tax sale certificate that you're just owning a billboard until you get to the end of it, unfortunately, because it just gives you a lot number, and it didn't, it's with the block and lot for a property, but it's actually just for the billboard. And don't ask me, that was like there's a certain municipality that does that all the time, and you have to really make sure that you're buying the land and not the billboard.
So it's in the legal description essentially of the.
And you have to really check with the tax office because there's no way to know from the title search that the lien is on the billboard. It doesn't tell you on the tax sale certificate that it doesn't say in big letters, billboard only.
Billboard
you don't
only.
get that.
Interesting. All right, well, and that's not just New Jersey; it's across the board. Is do your due diligence, and a very key point of that is keeping in mind that you may end up owning this real estate, right? So having somebody go buy the real estate, you or somebody you hire to go put eyes on that real estate is a very critical piece of the due diligence process.
Yes.
Awesome. And you had mentioned some other things that are pitfalls, but unavoidable. So fill me in on that.
Well, one that I really wanted to mention is bankruptcy, right? So you can't control if the property owner files for bankruptcy, but a lot of clients deem that a huge pitfall because obviously once an owner files bankruptcy, the foreclosure has to stop, right? Everything is stayed. That's, the provision is the automatic stay that's filed within the bankruptcy that prevents a creditor from proceeding with any action that's pending with the courts, right? So our clients deem that a pitfall. Now, granted, as a tax lien holder, you're a secured creditor. You're going to be repaid in full with interest in a bankruptcy if the bankruptcy is a repayment plan, right? So if there is a repayment provision, then you will get repaid. But most of my clients want the property.
Right.
So they view that as a pitfall. When they find out that someone's filed for bankruptcy, they find it very, upsetting. And they're like, oh, and, I try to explain if it's an individual and they're filing a Chapter 13, they have 5 years to pay off your lien in bankruptcy. And, I tell them, well, you're getting interest amortized over the life of the plan. So it's not like you're not making your interest, but they want the property. So to them, it's a major pitfall. And there's really nothing you can do. You didn't do anything wrong. But, bankruptcies are filed. They're not done every day. But especially now with the pandemic, we're seeing more and more owners filing for bankruptcy right now. So it's something to think about.
Got it. So it's the bankruptcy doesn't stop interest or reduce interest or anything like that. It puts the foreclosure on hold for up to 5 years, but you're still earning all of that interest. How are the subs handled in that time? Could somebody else? Is the county going to go sell the subs on that property, or is the bankruptcy control and everything?
Yeah, the county could file a motion to be permitted to hold an auction, and some municipalities do. The property owner is required under the bankruptcy to pay post-petition taxes as they come due. Okay, so that's a requirement within the bankruptcy. If they don't do that, that enables us to file a motion for stay relief, right? We can actually say the debtor isn't complying, hasn't paid the post-petition taxes, and therefore they are in fact jeopardizing our client's position, right? Their lien position by not paying. And that's a basis for stay relief. Normally what happens is if the debtor has the ability to pay those taxes within the plan, the trustee and the judge will allow the plan to be amended to include those post-petition taxes within the plan to pay them off. If they don't have the means to pay it off, though, then we can have stay relief and we can be allowed to proceed with the foreclosure.
Got it. Okay. Well, excellent. I guess, Deb, is there anything that I failed to ask you that you want to make sure gets known?
I think we really did a good job of covering almost everything there is to know about tax lien foreclosures in New Jersey. So there's nothing that I can think of off the top of my head, but I hope that we gave people an idea of what to expect in New Jersey if they're looking to do investments with tax liens.
Yes, it was immensely informative, and I've been in the industry for going on 12 years now, and I always love these interviews because I learn way more than you ever do reading an article or reading, even the white papers that do a great job of explaining it, just being able to ask questions. So I greatly appreciate it, Deb. I know the viewers will find it extremely informative. And I guess we'll meet at the next NTLA whenever that happens.
There you go. Looking forward to it.
Thanks, Deb. Have a great one.
You too. Take care.
All right. Take.